1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်986 G. San Nin Appellant vs. ဦး Ya Lik Respondent ဤစီရင်ထုံး Audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးစိန်သင် Judge G. San Nin Appellant vs. ဦး Ya Lik Respondent Suit for recovery of share capital a receipt granted acknowledging the receipt of money no stipulation regarding the time for payment Article 120 of the Limitation Act Chin's Special Divisions Extension of Laws Act Notification number 23 of the Chin Affairs Council Granting of relief on the principle of justice, equity, and good conscience. Hell, Exhibit Gaji is merely a receipt granted by the defendant acknowledging the receipt of a sum of debt 15,000. There is no stipulation regarding the time for repayment and from the nature of the alleged transaction between the parties, it is probably clear that the sum was not immediately payable at the time when it was drawn up, as the right to sue accrued on the day when the defendant refused to comply with the demand made by the plaintiff. Article 120 of the Limitation Act is applicable. Ramesh Wal Mande vs. Ramchan Rai 10 Calcutta 1033 1034 DB Distinguished Hell Father under the Chin Special Divisions Extension of Laws Act 1948, only certain portions of the Code of Civil Procedure are applicable to the Chins in the Chins Special Division. The parties to the suit being Chins, the content of the suit between them is regulated by Notification number 33 of the Chin Affairs Council, date the 2nd August 1949. From the judgment of the lower court, it appears that the relief was granted to the plaintiff on the principles of justice, equity, and good conscience, and therefore there is no reason for disturbing the judgment and decree of the lower court. Ula Nyo for the appellant, Mr. S.L. Verma for the respondent, Usain Din, Judge, in Civil Regular Suit number 1 of 1963 of the Additional District Court of Mindat within the Chin Special Division, the plaintiff respondent, Ya Lik, filed a suit against the defendant appellant San Nin. Among the many relief claims in the suit was one for recovery of debt 15,000, being the share capital contributed by the plaintiff towards the partnership business alleged to have been settled between the parties. It was the case of the plaintiff that there was a partnership between him and the defendant in connection with the road construction work for which the defendant had obtained a contract from the government. The plaintiff had already contributed various sums amounting in all to Jet 15,000 as his share towards the partnership capital, the stipulation between the parties being to enjoy the profits derived therefrom equally between them. After the completion of the work, the defendant is alleged to have drawn various sums of money from the government without making over anything to the plaintiff in spite of repeated demands. Hence, the present suit in which the plaintiff claimed, amongst others, recovery of Jet 15,000 only, waiving the sum of Jet 5,000 alleged to be due to him on account of his share of the profits accrued from the partnership business. The defendant, by his written statement, denied the allegations in toto. It was also contended that the claim of the plaintiff was barred by limitation. The trial court held that the alleged partnership between the parties was not proved. It, however, came to the finding that the plaintiff had advanced a sum of Jet 15,000 to the defendant. Regarding the question of limitation, the learned trial judge was of opinion that Article 120 of the Limitation Act was applicable and that the suit was therefore within time. A decree for the said sum was accordingly passed in favor of the plaintiff with cause. The only point that has been seriously canvassed in this appeal is that the suit was time-barred. According to the learned counsel for the appellant, the relevant article applicable to the suit is Article 57, which prescribes a time limit of 3 years from the date when the loan is made. The exhibit Gaji, which acknowledges the receipt of Jet 15,000 by the defendant, is dated 11 April 1958, and this date, according to the learned counsel for the appellant, being the time from which the limitation period begins to run, the suit should have been filed on or before 11 April 1961. I am, however, unable to subscribe to this view. From the very wordings of Article 57, it seems clear to me that it is applicable only in respect of a loan which is immediately payable. Exhibit Gaji is merely a receipt granted by the defendant, acknowledging the receipt of a sum of Jet 15,000. There is no stipulation regarding the time for repayment and from the nature of the alleged transaction between the parties, it is palpably clear that the sum was not immediately payable at the time when it was drawn up. The word payable in Article 57 has been held to mean payable at once on the loan being made. Thus, in Rameshwar Mande vs. Ramchand Rai 1, it was held that where a loan is on an agreement that it is repayable on a future date, it cannot be said to be payable immediately on the loan being made, and a suit for recovery thereof is not for money payable for money lent within the meaning of Article 57. I would accordingly hold that, in respect of the suit out of which this appeal arises, Article 57 of the Limitation Act is not opposite. It is next contended that as the suit is one based on partnership, Article 106 is applicable. Here again, I'm unable to follow the line of contention advanced by the Learned Counsel for the appellant. As pointed above, the lower court has come to a finding, which finding is not unwarranted by the evidence obtained on the record of the lower court, that the existence of partnership was not proved. It is therefore clear that Article 106, which relates to a suit for an account and a share of the profits of a dissolved partnership, is not at all applicable. A relevant article is obviously Article 120, which prescribes a time limit of 6 years from the day when the right to sue accrues. In the present case before me, the right to sue accrued on the day when the defendant refused to comply with the demand made by the plaintiff. The suit, which was filed on the 17th September 1963, was therefore still within time. Lastly, the Learned Counsel for the appellant, in the course of his arguments before me, has pointed out that the relief granted to the plaintiff is not consistent with the nature of his claim in the suit, which was essentially a suit for accounts. It must, however, be borne in mind that under the Chin Special Division's Extension of Laws Act 1948, only certain portions of the Code of Civil Procedure are applicable to the Chins in the Chin Special Division. The parties to the suit being Chins, the conduct of the suit between them is regulated by notification numbered 33 of the Chin Affairs Council, date the 2nd August 1949. From the judgment of the lower court, it appears that the relief was granted to the plaintiff on the principles of justice, equity, and good conscience, and I therefore see no reason why the judgment and decree of the lower court should be disturbed. In the result, this appeal fails and is hereby dismissed with cause. Advocate fee fixed as 2 gold mohurs.